Hi everyone, welcome to today's webinar on protecting your e-commerce or retail brand. My name is Rebecca Jones and I'm a practice group leader in LegalVision's Trademarks team. I'm joined today by my colleague Akshaya, who is a lawyer in the Trademarks team. We'd like to start with an acknowledgement of country. LegalVision acknowledges and pays respect to the past, present and emerging traditional custodians and elders of this nation. In particular, the Gadigal people of the Eora Nation, whose land LegalVision's headquarters is situated on, and the various lands on which those of you are joining us today. Now, before we begin, a couple of quick housekeeping items. Everyone registered for this webinar will receive a copy of the webinar recording by email. If you have any questions throughout the webinar, please submit them in the chat box. And we'd really appreciate it if you could take a moment to complete the survey after the webinar. Your feedback is really important to us. Today we will be discussing choosing a good brand name and logo, trademark, domain name and business name registrations, international trademark protection, and protecting your brand against copycats. At the end of the webinar, we'll be answering some of your questions submitted via the chat function throughout, as well as some of those submitted ahead of time. At the end, we'll also have a special offer for our attendees. And now Akshaya will speak about choosing a good brand name and logo.
Hello everyone. So the first topic I'll cover is briefly explaining what a trademark is. A trademark is a sign that functions as a badge of origin for your business. And it's something that consumers will associate with your business in the marketplace. So a trademark can be a word such as Adidas, a logo such as the famous Nike swoosh or the tick device that you see on the screen there, or even a sound or a smell, although these are a little less common. Most businesses and e-commerce brands generally tend to protect a word or logo as a registered trademark, and your trademark can be one of the most valuable assets of your business. It's what your reputation and goodwill attaches to as a brand. It's also the way that your loyal customers recognize your goods or services, and it's therefore really important to select a good trademark and to protect it as well. Now you might be wondering, what makes a good trademark? Well, a good trademark is one that's distinctive and capable of distinguishing your business from other businesses in the marketplace. The test for distinctiveness is whether another trader, lacking improper motive, is likely to need to use the same trademark to describe similar goods and services. A good trademark is one that's not descriptive, as these are difficult to register and enforce in the marketplace. For example, a descriptive trademark is one that contains geographic references, such as Sunshine Coast, for goods or services originating from the Sunshine Coast. Another example of a descriptive trademark would be T-shirt store or homewares market. By comparison, an example of what makes a good trademark will be Apple's Apple logo. So the Apple logo, as we know it, was actually completely different from the one that we see today on all of Apple's products. The initial logo was designed by Steve Jobs, and it was much more complicated looking, as you can see on the screen there. And it depicted Isaac Newton sitting below a tree with an apple falling on his head, which was supposed to be a tribute to his discovery of gravity. That logo was eventually replaced in the 70s by a rainbow-colored silhouette of an apple with a bite taken out of it. And eventually, in 1999, the color of the Apple logo became monochrome. The designer Bob Janos claimed that the apple is supposed to be a simple connotation to knowledge, and it's a really great example of a successful and simple logo that now conveys a well-known brand message. Another great example is Nike's swoosh logo. It's arguably one of the world's most recognizable logos, and Nike's swoosh logo was initially designed by university student Carolyn Davidson for just $35. She was approached by a then unknown track runner, Phil Knight, and his coach, Bill Bauerman, who needed a logo for their new line of running shoes. Of course, these men are now famously known as the founders of Nike. And at the time, the pair had just come up with the name Nike, named after the Greek goddess of victory. After Carolyn Davidson handed over the design, Phil Knight was apparently really slow to see its potential, and he reportedly said at the time, "I don't love it, but it'll grow on me." So as you can tell, the Nike and Apple logos are great examples of distinctive and unique trademarks. And as a consumer, you can recognize the brand instantly in a store just by seeing the logo on the product. These logos have also become so synonymous with the brand that the brands don't even need to include their name on the products at times. And not only are the logos distinctive, but so are the brand names themselves. Before adopting your trademark, you'll want to make sure that it's available for you to use and register. You don't want to put all the effort into launching your brand, only to receive a cease and desist letter and find out that you've inadvertently infringed on another party's trademark. You should first conduct some searches of IP Australia's database, as well as the general marketplace, before adopting a trademark, to see whether there are any existing trademarks that are the same or similar to yours. Now, you might be wondering, what if I find a similar trademark to the one that I want, but the goods and services are different? Well, similar brands can coexist in the marketplace and on the trademarks database if the goods and services are different and the consumer base of each business is unrelated. And now Beth will speak a little bit more about the factors to consider when you're getting ready to launch your business.
Thanks. So when you're getting ready to launch your e-commerce or retail business, there are a few different types of registrations that you'll want to attend to. Ideally, before you settle on your trademark, you'll want to ensure that corresponding business names, social media handles, and domain names are available for you to register as well. Having these different IP assets line up can ensure brand cohesion and also ensure that customers know where to find you online, which is obviously super important for e-commerce businesses. It's important to understand the difference between a business name registration and a trademark registration. It's a common misconception that registering a business name entitles you to use the name as a trademark and vice versa. Registration of your business name allows you to trade under that name without breaching ASIC's business name requirements. It does not, however, ensure that you are not infringing a third-party trademark when you trade under that name. Registering a trademark, on the other hand, protects the use of that trademark in your branding. If your trademark is also the name you are trading under, as opposed to just the name of a particular product or service you're offering, then you'll need to have a business name or company registration that matches as well. This is to ensure that you don't fall foul of ASIC's requirements. This means that when considering the trademark that you want to adopt, it's also wise to check whether the company or business name is available for registration with ASIC. You'll also want to secure relevant social media handles and domain names. Once you've decided on your trademark, carried out the relevant availability searches, and you're ready to proceed, it's time to apply to register your trademark. It's best to get your application underway as soon as you've decided on your trademark to secure the earliest priority date possible and to ensure that nobody beats you to it. Trademark registration in Australia is administered by IP Australia, which is a government department. When you're filing an application to register your trademark with IP Australia, you'll include the trademark that you want to protect, the goods and services that you want to provide under it, and the details of the trademark owner. You'll want to think about the various aspects of your branding that you might want to protect. For example, a word mark for your business name, an eye-catching logo that you use in your business, catchy taglines, and so on. You might want to file multiple applications to protect these different trademarks that are used within your branding. You should also think about the scope of your protection and the relevant classes of goods and services to cover in your application. There are 45 classes of goods and services. Classes 1 to 34 cover goods and classes 35 to 45 cover services. The most relevant classes for e-commerce or retail businesses would likely be class 35, which covers retail services, including online, and then the goods classes covering the goods that you provide under the trademark. For example, class 25 covers clothing, class 20 covers furniture, class 14 covers jewelry, and so on. Once your application is filed, IP Australia will examine it to see if it can be accepted for registration. The main things the examiner is looking at is whether there are any similar trademarks on the register and whether your trademark is distinctive enough to qualify for registration. If any issues are raised during examination, you'll be given 15 months to overcome these. There are lots of options for attempting to overcome objections that might be raised by the examiner during examination. These include seeking consent from the owner of a cited mark, amending your specification of goods and services, filing submissions in an attempt to convince the examiner to withdraw the objection, filing evidence of your use of the trademark, or removing cited marks from the register for non-use. Once you secure acceptance of your application, it's advertised for opposition purposes for 2 months. If no opposition is filed, then it proceeds to registration. Your trademark will be registered for 10 years and can be renewed for subsequent 10-year periods indefinitely, subject to payment of government renewal fees. It's really important to note that your Australian trademark registration protects you in Australia only. If you're trading in other countries, which is pretty common these days with e-commerce businesses, then you'll want to protect your trademark overseas as well, in the countries that you're trading in. Akshaya will now take us through some international trademark protection considerations.
Great. So as Beck mentioned, we'll now explain how international trademark protection works and how this might be relevant to your e-commerce business. So you might find that your e-commerce store has a really significant customer base in numerous international markets. And once you've sought to register your trademark in Australia, international trademark protection may be at the forefront of your business considerations. International trademark protection is particularly relevant if you intend to actively market your goods or services and promote your business internationally through various advertising outlets, including social media. And many well-known fast fashion e-commerce brands in the marketplace have already taken their brand protection one step forward to protect trademarks internationally. An example of this would be a current trendy retailer, such as Pretty Little Thing, who are a popular women's fast fashion brand based in the UK. They have a really strong social media following of about 18 million users at the moment. And this brand has essentially strengthened their international trademark protection, extending from its base in the UK to Australia, China, the European Union, New Zealand, and the United States. The company appears to have protected the brand and its 14 current trademarks via the Madrid Protocol system, a process which I'll expand on shortly. Trademark registrations are governed by the domestic laws of each country. You can protect your brand internationally through 2 methods. Firstly, by applying to register your trademark directly with a national office in a desired country, or by filing through the Madrid Protocol system. It's important to remember that while trademarks can be registered and enforced internationally, there's no such thing as an all-encompassing global trademark. In some instances, having a registered or pending trademark internationally may be a requirement to trade on certain international platforms. For example, you'll need a valid trademark to sell your goods on Amazon. It's also important to consider where you might like to offer your goods and services in the next few years and to review the trademark protections that your competitors in the marketplace have already put in place. Circling back to the filing methods, you can basically file a direct national application to a particular country of interest. This might be particularly relevant if you know that your customer and trading base will be restricted to one region. Some jurisdictions also cover multiple countries, for example, the European Union, but in most cases, a direct national application will cover just one country. If you have no intentions of trading in Australia, you may even consider skipping the Australian trademark protection route and applying straight away to a national office overseas. Alternatively, you might be interested in a more global protection. The Madrid Protocol filing system is a convenient and cost-effective solution for registering and managing trademarks worldwide. The Madrid Protocol system allows prospective registrants to file a single application directly to the World Intellectual Property Organization, known as WIPO, and select from a list of member countries that are signatories to the Madrid Protocol. Currently, there are about 126 member countries, and applicants can renew and expand the reach of their trademark protection through this centralized system. To be eligible to register through the Madrid Protocol, you must have an existing trademark or a pending application in at least one domestic jurisdiction. A Madrid Protocol registration also depends on your domestic trademark, which is known as the basic trademark. And this dependency period remains for about 5 years. This means that if your Australian application does not achieve registration or is removed, you must review your international registrations accordingly. This might mean that you need to convert the international registration to national application. It's also important to note that IP Australia manages Australian trademark renewals, but WIPO manages international trademark renewals. And by failing to renew your international registration in time, you may risk losing protection in the designated countries. And now Beck will expand a little bit more about protecting your brand against copycats.
Thank you. So say you've got your trademark protection in place, you've launched your business, you're seeing success, you must beware the perils of popularity. They say that imitation is the highest form of flattery, and it's certainly something that many successful brands contend with on a daily basis. Once you've registered your trademark, you will be in a much stronger position to take action against third parties that may attempt to copy your branding. These third parties may attempt to ride off your coattails, cause confusion amongst consumers, or attempt to pass their goods and services off as yours. This can be particularly problematic in the e-commerce space and on platforms such as Alibaba or Amazon, where it can be relatively easy for third parties to put up listings and sell counterfeit goods. There are a few ways that you can protect your brand in this landscape. First of all, it's really important to take swift action against copycats. If you allow third-party unauthorized use of the same or a similar trademark to go unchallenged for a long period of time, that third party may start to accrue their own common law rights in that trademark. It may then be harder for you to stop them later down the track. If you become aware of a third party making unauthorized use of a similar trademark for the same or similar goods, then as a first step, you should get legal advice swiftly so that you can understand your position and the options available to you. Options might include sending a cease and desist letter to the unauthorized user, demanding that they cease the infringing conduct and provide certain undertakings not to do it again in future. If the conduct persists, you may be able to take action in court on the basis of trademark infringement, misleading and deceptive conduct, and passing off. There are some other avenues available to you as well. So many online platforms these days have very useful and effective IP complaint procedures and takedown policies. If you see a third party making unauthorized use of your trademark on social media platforms such as Facebook or Instagram, or on e-commerce sites such as Alibaba or Amazon, you can file a complaint and takedown request with the platform's IP complaints department. It's worthwhile making sure that you're aware of the policies of the different platforms that you are trading on, so that you're familiar with the tools available to you should you need to use them. It may be easier to take swift action if you've pre-registered your rights, for example, with Amazon's brand registry. Another avenue for taking action is via domain name complaints. If another party uses a similar name as a domain name to try and confuse consumers and redirect them from your website, you may be able to resolve this by filing a complaint under the relevant domain name dispute resolution policy. If you find that your brand and products are the target of counterfeits, you could also consider putting customs notices in place. This involves registering details of your trademarks and products with customs at any particularly problematic international borders. Customs officers will then be able to identify and stop any counterfeit products being imported or exported. Another tool available to you is trademark application opposition procedures. If you become aware of another party attempting to register a trademark that is confusingly similar to yours, you could take the opportunity to oppose it when it is advertised for opposition purposes. In this way, you can attempt to prevent the trademark from proceeding to registration in the name of that third party. Many of these avenues are available in numerous countries around the world. So if you're an e-commerce business trading internationally, there are likely to be a range of tools available to you to take action against unauthorized conduct that might damage your brand. The strategy will depend on the country where the conduct is taking place, as well as the nature of the conduct itself. Your strategy might include a combination of the different actions that I've just discussed. The last thing I'd like to cover off is trademark monitoring. So we've established that it's important for you to take swift action against infringers, but you can only take action if you know about an issue. For this reason, it's important to monitor the market for infringing conduct. You can do this by keeping an eye on different marketplace platforms, social media, and internet listings. A useful tip is to set up a Google alert, which includes your brand, so that you'll receive an email alerting you to any listings or commentary about your brand online. It also pays to keep an eye on trademarks being filed in the countries of interest to you. That way, if a third party files an application for a trademark that you have an issue with, you will have the opportunity to oppose it when the application is advertised for opposition purposes. It's a good idea to put these types of watches in place, tailored to suit your particular needs and the high-risk areas to your e-commerce or retail business. It's also wise to monitor Australian trademark filing activities. This might involve keeping an eye on what specific competitors are filing, making sure that nobody is applying to register a trademark that is similar to yours, or just getting general intel on the trademarks being filed in the particular classes or industry of interest to you. For example, you might have a big e-commerce or retail competitor overseas who hasn't yet ventured into the Australian market. By being notified if they apply to register their trademarks in Australia, this may give you some insights into their plans to enter the Australian market. So to summarize, registering your trademark is a vital first step, but the work doesn't necessarily stop there. It's important that you monitor the marketplace and be prepared to enforce and protect your brand against third parties that may cause damage to it. So that brings an end to the presentation part of our webinar. You may find our Trademark Essentials Guide useful. You can download this via the handout section in your webinar panel.
Also coming up is another event that you might find interesting if your e-commerce brand is hiring employees from around the world. On the 22nd of September, my colleagues will be hosting a webinar on Global Talent Visa and how to make your EOI stand out.
Excellent, and now we will answer some of your questions. Okay. Akshaya, I might throw this one to you. When is the best time to apply to register my trademark overseas?
Great. Well, this is a question we get a lot, and it can be really difficult to decide when to look at overseas trademark protection, especially if you're a startup and you have a limited budget. So it's worthwhile looking into it pretty much as soon as you can. And ideally, the best time to apply to register your trademark overseas is after you've filed a corresponding Australian trademark application. And you're considering an expansion into any international regions roughly within the next 2 to 5 years. It's important to remember that each country has its own examination periods, with some countries, such as Canada, taking up to 2 years to even examine an application, unlike Australia, where this is a 2 to 4 month period. So if you're planning on launching in Canada within 2 to 3 years' time, you might want to get trademark protection underway there as soon as possible, so that your trademark will be registered before you actually launch your business activities. Furthermore, it's really important to prioritize protection in some regions, even if you are thinking about long-term expansion plans. Another example would be that of China, where China has what's known as a first-to-file system. This means that the applicant who is the first to file a trademark is the owner of that trademark. So any business owner seeking to expand into the Asia-Pacific regions should seriously consider international protection in China at the earliest opportunity. Once you've decided to go ahead with an international application via the Madrid Protocol system, which I described earlier in the presentation, you can use the Australian priority date to claim priority within 6 months from filing a corresponding domestic application. Essentially, what this means is you can backdate an international application to reflect the Australian date of filing, even if you file it 3 or 4 months afterwards. And it can be a really useful way of staggering costs as well across your domestic and international applications. However, as we discussed earlier in the presentation as well, it probably might be more relevant for your business to skip the Australian registration process and even apply directly to a national office in your country of interest if it's more relevant for your business and if you have no intentions of trading in Australia.
Great, thank you. The next question is, if a retail competitor applies to register a similar trademark to mine, what is involved in opposing this? So as a first step, if you become aware of a third-party trademark application that you're concerned about, I would suggest that you get advice from a trademark specialist about the prospects of success in opposing the application. If you do decide to proceed with opposing the application, the steps involved start with filing a notice of intention to oppose with IP Australia. You have 2 months to file this document after the trademark has been advertised for opposition purposes. 1 month after that, you'll need to file your statement of grounds and particulars. This sets out the grounds upon which you're opposing the application. And there's quite a few grounds available, but I would say that the most common would be that their trademark is similar to your registered trademark, that they don't have an intention to use the trademark they've applied for, that their trademark application was filed in bad faith, or that due to your reputation in your trademark, use of their trademark would cause confusion, mislead or deceive consumers, or amount to passing off. You would usually include a number of grounds of opposition, but you only need to successfully establish one ground to succeed in opposing the trademark application. So once you've filed your statement of grounds and particulars, the other side needs to notify IP Australia that they intend to defend their application. They do this by filing a notice of intention to defend. Once they've filed that, the proceedings would then move into the evidence stage. Both parties have the opportunity to provide evidence to support their position. For the opponent, that would likely include evidence of your use and reputation in the marketplace, any evidence that you have of the other party acting in bad faith, and examples of instances of consumer confusion between the brands, if you're aware of any examples of this and have evidence of it. Once the evidence stages are complete, the parties then have the opportunity to request a hearing. This can be by way of written submissions or an oral hearing, or you can elect to simply have the matter decided on the basis of the evidence filed to date. A hearing officer will then consider all of the materials filed and the arguments put forward by each side, and will issue a decision on whether to register or refuse the opposed trademark. There's probably a few other things that I should mention about trademark oppositions. The first being that costs are usually awarded to the successful party. It's good to bear in mind, though, that these are scale costs rather than full costs, so they will usually only cover a portion of the costs that you actually incurred. Decisions of IP Australia can be appealed up to the Federal Court. And it's often worthwhile considering the option of attempting to negotiate a settlement with the other side to see if the matter can be resolved amicably without the need to proceed all the way through to a hearing. If the parties are engaged in settlement negotiations while an opposition proceeding is ongoing with IP Australia, it is possible to obtain a calling off period with the consent of both parties. And what this will do is essentially halt the proceedings and allow the parties time to try and reach an agreement. Here's one for you, Akshaya. This is one that was submitted ahead of the webinar. I want to start my Amazon business. Want to know about trademark, domain, business name, etc. related to Amazon.
Cool. So yeah, we touched on a few things about Amazon in the webinar. So hopefully that answers your questions overall. But just to summarize, you're likely need a trademark to sell your goods on Amazon. This could be in the form of either a pending application or one that's already registered. And if you want to enforce this trademark in Australia specifically, having the business name and domain name is probably a good idea as well.
Thank you. Next one. I tried to register my brand name and it wasn't accepted. Where to from here? Now, this will really depend on the reason that your application wasn't accepted by IP Australia. And this would have been set out in the examination report that you received. So what we can do here is take you through some options for responding to an objection. Maybe I'll go through some options for dealing with a descriptiveness objection first, and then I'll pass to you, Akshaya, and you could cover off the options for a cited mark objection.
Yep.
So if the objection was raised under section 41, that means the examiner thinks your trademark is descriptive and therefore not sufficiently distinctive to be entitled to registration. There's quite a few options for overcoming this type of objection, and they include filing submissions. For example, if we think the examiner has incorrectly assessed the trademark, we would point out that it is in fact capable of distinguishing your goods and services from those of other traders. our arguments might include some state of the register type evidence and arguments, and this is where we point out to the examiner other trademarks that have been accepted with a similar level of distinctiveness. And we would use this to support arguments that your trademark application has been incorrectly assessed and your trademark should be entitled to registration as well. Another option is to amend your specification. This applies if the objection relates only to part of your claimed goods or services. You could also file evidence of your use of the trademark. So if you've used the trademark extensively or for a long period of time, it might be possible to overcome the objection by filing evidence of your use. The purpose of this is to demonstrate to the examiner that because you've made extensive use of your trademark, that it has come to be exclusively associated with your business in the eyes of consumers. And one last option that I'll mention is when it comes to a descriptiveness objection, you also have the option of refiling for a logo version of your trademark. So assuming that you filed for a word version of your trademark and it is in fact not distinctive or it is descriptive of your goods and services, and say you haven't made sufficient use of it to succeed by filing evidence of use, then you could file for a logo version of your trademark instead. The additional distinctive visual elements in your logo might be enough to get it across the line in terms of distinctiveness and to allow you to secure some protection in the meantime. If the objection was not raised on the basis of distinctiveness and was perhaps raised instead under Section 44, this means that there are existing trademarks on the register that the examiner considers are too similar to your trademarks. So there's quite a few options for overcoming this type of objection as well, and I'll let Akshaya take us through those.
Great. So again, you have the option of filing submissions in an attempt to convince the examiner to withdraw that type of objection. And we would probably need to argue that the trademarks are not deceptively similar and are capable of coexisting without consumer confusion occurring. Another option would be to amend your specification. If you're able to remove the overlap between your goods and services and those covered by the cited mark, this might be a really great option. So if you adopt this approach, you'll need to make sure that your remaining specifications sufficiently covers your actual business activities. Another option would be to file evidence of use. It may be that you could overcome this type of objection using this method as well. And in this case, you'd be attempting to demonstrate to the examiner that either you have been using the trademark continuously since before the priority date of the other trademark, or that you adopted it honestly and have been using it concurrently alongside the cited mark. And this could be over a decent period of time without consumer confusion occurring. Another option would be to approach the owner of the cited mark to seek their consent to your use and registration of your trademark. This can carry some risks, as it might prompt them to object to your trademark, but it's more likely to be a viable option where there's no commercial conflict between the parties and they're not competitors in the marketplace. The last option I'll mention is applying to remove the cited mark for non-use. At a certain point after registration, trademarks become subject to a use requirement. This means that if the cited mark hasn't been used for a 3-year period, it may be vulnerable to removal for non-use. If removed from the register, it would no longer form an obstacle to your application. So to summarize, if you've received an objection from IP Australia, there are usually plenty of options available for attempting to overcome it. I'd recommend getting advice from a trademark specialist to determine the best strategy going forward.
Thanks, Akshaya. Another one that's come through just today, how do we register in Europe? Does the Madrid Protocol system cover this? I think Akshaya covered this off earlier. Yes, the European Union is a member of the Madrid Protocol, which means that if you file an international application via the Madrid Protocol, you can list the EU as a designated country under your international application. That would give you protection in all member states of the European Union. Another question here, if I've only made a few sales, can the other party take away a registered trademark? Generally, no. When it comes to non-use of a trademark, there needs to be a 3-year period where there's been no use of the trademark made. It's not really done on the basis of assessing how much use you've made. There isn't a particular threshold where you have to have been making extensive use of it. So generally, if you've made some genuine use of the trademark, then you should have a good chance of defending an action for non-use. Here's one for you, Akshaya. We might have covered this off earlier, but just to recap, once a trademark is filed, does that last forever? What is the renewal period?
Yeah, good question. So the renewal period is essentially 10 years. Once you have a registered trademark, you can renew it in 10-year increments, provided that you are still using it in those related goods or services that you've applied for. And this applies to your Australian applications as well as any international ones as well.
I guess maybe one thing we should mention there is another thing to bear in mind when it comes to renewing your trademark. Things might have changed in the 10 years since you registered it. You might have expanded into additional classes of goods and services. So that can also be a good time to look at whether you need to file new applications. Perhaps you've got a new logo, or your branding's been tweaked. Perhaps you've expanded into a different area, you're providing different goods and services. So it's also worthwhile making sure that your protection stays up to date as well. Okay, I have trademarked company name in Australia and secured the company name and domain names in other countries. However, I saw someone who was trying to use the same name in one of those countries. What happens? So the best course of action here will depend on a range of factors. For example, which country is this conduct happening in? Exactly what rights do you have in that country, and how are those types of rights able to be recognised and enforced in that particular country? So we'd probably be looking at things such as, do you have a registered trademark in that country? If so, that should make things easier for you to be able to take action. But even if not, there may be other avenues available to you. For example, you might have a reputation in that country that you could rely on under the common law to take action. I'd also look at other options, such as if you have the company name registered in that country, is this third party breaching some sort of regulations by trading under that name, similar to what I touched on earlier regarding ASIC's requirements. So there are a lot of different factors at play, and each case is different and depends on the facts. I'd suggest engaging a lawyer in that country that specialises in intellectual property. They'd be able to advise you on the strength of each party's position, the potential options available to you under local laws, and to help you decide on the best course of action. Okay, one for you, Akshaya. What's the difference between the R symbol and the TM symbol?
Yeah, so this one's a really common question we get from a lot of people. And it's really important to know the difference between the registered symbol, so the one using the letter R in a circle, and the TM symbol. So the TM symbol can be used on any trademark, particularly to demonstrate you are seeking to enforce your rights in relation to the trademark. And the difference is that the registered symbol can only be used in relation to a registered trademark, so one that you receive a certificate of registration on. If you use the registered symbol next to an unregistered trademark, it's actually a punishable offence under criminal law, and you might be slapped with a fine. And so I think that's all the time we have for questions. Well, we would love to assist you all further in the future if you're thinking about setting up an e-commerce store, or even if you've already got a successful business and are just looking for some legal advice. Our services at LegalVision are offered through a membership where our clients get access to a team of over 100 in-house lawyers with expertise across various areas of commercial law. Our members have access to unlimited document drafting and reviews, and unlimited Australian and New Zealand trademark applications. Our members can also book in for unlimited legal advice consultations and get all their business legal needs sorted for an affordable monthly fee. And webinar attendees today are actually eligible to receive a complimentary consultation to discuss how we can help you with registering and protecting your trademark. So if you want to go ahead and book a complimentary consultation, just leave your contact details in the survey that will appear after the webinar ends. You can also send us an email via the email address on your screen there and mention that you watched this webinar. So that's all for today. Thank you so much for joining us.
Thanks, everyone.